Hello there, I'm Stephanie Haney. I'm a legal analyst licensed to practice law in California and Ohio, and this is Legally Speaking. Here we talk about important legal issues that impact all of us, and we break it down as simply as possible so that we can all better understand what is going on in the world. Today we're talking about the United States Supreme Court and the most recent rulings handed down. I'll explain a few, and we'll be joined by several experts to talk through a few others, along with taking a look at the history and the future of the court itself. Let's start with a scenario that's very familiar to all of us, whether you've ever been arrested or not. If you've watched any episodes of Law & Order or any cop show, you know police have to tell suspects, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand? These are your Miranda rights, and in Vega versus Tekoh, the Supreme Court ruled 6-3 along conservative and liberal lines that police officers who read these rights to suspect in their custody, if they don't read them, they cannot be sued in civil court. Joe Dana with KPNX in Phoenix has background information for us.
The 1963 arrest of a man in Phoenix led to a landmark Supreme Court ruling that is a household phrase. Police are required to tell suspects in custody of their Miranda rights, notifying them of their right to remain silent and their right to speak with an attorney. On Thursday, the Supreme Court ruled suspects who are not notified of their Miranda rights do not have the option to sue police for damages later.
It is another consistent weakening of the Miranda doctrine.
ASU law professor Gary Stewart wrote a book on Miranda rights. Stewart says the decision by the Supreme Court is based in good faith and is a sound legal decision reflecting the conservative makeup of the court. However, he warns it could do harm.
Well, it will encourage that tiny minority of police officers. It's a tiny minority who abuse these rules routinely, who solve crimes by lying to suspects, by not telling the suspects what their constitutional rights are.
This is one of the most completely wrong opinions of the Supreme Court I've read recently.
ASU constitutional law attorney Paul Bender is more critical of the court, saying the right to sue should not be taken away.
The reason why there's a federal statute that gives you damages if your constitutional rights are violated is because the federal government, Congress, thinks that if your constitutional rights are violated and it harms you, you ought to be able to recover damages.
The decision means police officers will have one more level of immunity as they do their jobs. Joe Dana, 12 News.
So what does this mean? The bottom line here is this ruling does weaken the protection of Miranda rights. It takes away a remedy outside of criminal court that is meant to deter police from behaving badly, from using coercive techniques to try to get people to incriminate themselves. This all centers around a federal law, Section 1983, that allows civil lawsuits for damages, money, against a government official for violating constitutional rights. Nothing is happening with this law. This law is still good law. This Supreme Court, though, made this distinction that the Miranda warning protects a constitutional right, the right against self-incrimination, but there is not a right to actually be read the warning itself. And so not getting that warning will not trigger the ability to file a civil lawsuit. So the requirement to read people their Miranda rights, it's not going anywhere. And evidence, like confessions that come from not being read Miranda rights, can still be excluded from trial. But now people will not be able to sue if they are not given this warning. Something else that's ending is the so-called Remain in Mexico policy that was initiated during former President Donald Trump's administration. Formerly called Migrant Protection Protocols, this is the Trump-era policy that sent certain non-Mexican citizens who entered the U.S. back to Mexico while their immigration proceedings played out. This was rather than detaining them here or releasing them into the U.S. President Joe Biden has been trying to end this policy, and those efforts have been challenged in lower courts. But in the Supreme Court case of Biden versus Texas, the court ruled 5-4 in an opinion written by Chief Justice John Roberts that the Department of Homeland Security has the discretion to end it. So now we bring in our first guest, Cesar Garcia Hernandez, Texas attorney and law professor at The Ohio State University Moritz College of Law, coming to us from Colorado to answer a few questions about what this decision means and what's next. Cesar, hello. Thank you for joining us on Legally Speaking.
It's my pleasure, Stephanie.
Okay, let's start with the losing side. What was the Texas argument against ending the Remain in Mexico policy?
Texas and a handful of other Republican-led states initiated this lawsuit claiming that the Biden administration's attempt to, or announcement that it was planning to end the Trump-era migrant protection protocols, more commonly known as Remain in Mexico program, violated federal law in a couple of ways. The most important, I think, is by claiming that Texas claimed that federal immigration law, it gave the administration two options when it came to migrants who were arriving at the southwest border. The Department of Homeland Security could either detain people in the network of immigration prisons run by the Immigration and Customs Enforcement Agency, or they could return these individuals to Mexican border communities to wait the outcome of their hearings. That was the position that the states pushed all the way to the Supreme Court.
Okay, so ultimately that either or argument did not win out, but it is not exactly as simple as just ending the policy now, because the question is what has to be done to do it. So what happens now?
Yeah, well, certainly at the U.S. Supreme Court, the majority of the justices disagreed with the position that the states took. And instead, they said, actually, the Department of Homeland Security, the federal government, has a number of other options. Yes, they can detain people. Yes, they can send people back into Mexican border communities, or they can choose to allow people into the United States under what is called a parole authority, which is a practice of allowing people into the United States while their immigration court proceedings are ongoing, that every presidential administration going back decades has implemented to one extent or another, including the Biden administration and the Trump administrations most recently. But I think the other underlying consideration that was really front and center in the Supreme Court's decision were the foreign policy considerations that the migrant protection protocols really triggered. That is, when the federal government gets to implement and enact immigration laws and immigration policies, so long as that's happening within the United States, that's up to the Congress and the president how and what exactly to do. But when it comes to sending people outside of the United States, then all of a sudden you're dealing with a separate foreign government. And not only is the Constitution pretty clear that that kind of diplomatic relation is in the hands of the president, the Supreme Court for many, many decades has also insisted that those are the kinds of diplomatic, touchy diplomatic concerns that are best left to a single unit of the federal government, namely the executive branch headed by the president. And the Supreme Court was really not interested in having the courts, like the federal district court, that sort of first ruled on the state's legal challenge to the Remain in Mexico program, really pushing the administration to sit down at the negotiation table with the Mexican government here, specifically enforcing the the U.S. government's hands. And so now it's up to the Biden administration to figure out how and if and when it will actually end the Remain in Mexico program. As of the moment that you and I are speaking, Stephanie, so far the administration has not ended the program. It now has clear authority to do so from the Supreme Court. But now it's a question of when, how, and frankly, if. And so far, the Secretary of Homeland Security, Alejandro Mayorkas, says that they continue to plan to do so. And he has sort of vaguely said sometime in the next few weeks, the Department of Homeland Security will actually end the program. It's really a question of waiting and seeing when and if that happens.
Gotcha. Thank you very much for your expertise on this, Cesar. Obviously, lots of moving parts here. We appreciate your time. Enjoy those beautiful Colorado mountains.
Thank you.
Now we turn to the issue of religion in schools with two cases to talk about. First, prayer in or at least around official school activities. In the case of Kennedy versus Bremerton School District, in a 6-3 ruling, the Supreme Court held that a high school football coach praying on field after a football game was protected speech under the First Amendment. Lawyers for the school district argued that Kennedy's prayers on the 50-yard line weren't private or personal, that they were a ritual happening in full view of students that the school district was justified in restricting. We go now to Bremerton, Washington, just across the bay from Seattle, where Drew Mickelson spoke with the coach in this case.
When the district warned Coach Joe Kennedy to stop leading his on-field prayers, he refused. The Bremerton School District suspended him, and his contract was not renewed the next season. The coach sued, saying his rights had been violated. And with a 6-3 majority vote, the U.S. Supreme Court agreed.
Thank God and everybody that supported me throughout this. I mean, it's just great news for the entire nation.
The district argued the prayers, led by the team's head coach, compelled or coerced players to participate unwillingly to get in good with the coach. The district offered Kennedy other places to pray as well.
What kind of message does that send, that I should hide who I am and my beliefs? Bremerton is one of the most diverse schools and inclusive schools around. And, everybody should be, free to be themselves, no matter what it is.
Parents all around this country should be afraid right now.
Attorneys for Americans United for Separation of Church and State, who argued against the coach's case, fear the implications of the decision.
Can we expect to see prayer in the classroom under this ruling today?
We think it opens the door to coercive prayer in K through 12 classrooms across the country.
Where else is that going to pop up in public spaces?
Bremerton Reverend Greg Reffner traveled to Washington, D.C. with other Kitsap County clergy, speaking out against the coach. While the Reverend supports prayer, he says it should not be happening at school.
I think there are a whole number of better, more faithful ways to share one's faith than to do what Coach Kennedy did.
Kennedy now lives in Florida, but he says he would be on the first plane back here to Bremerton if he could get his old job back. The lawyer who fought against the coach at the Supreme Court says it's not clear what the school district is going to do about the coach's future here.
We'll talk more about a major case being overruled later, but this decision in the Kennedy case also overrules a case. It overruled Lemon versus Kurtzman, and in that case, the Supreme Court found that 2 states, Pennsylvania and Rhode Island, violated the Establishment Clause by making state financial aid available to church-related educational institutions. The Establishment Clause of the U.S. Constitution prohibits the government from making any law respecting an establishment of religion. This means the government can't establish an official religion or do things that excessively favor one religion over another. The Lemon case spelled out a 3-part test to see if the government was doing any of those things. But the way the test worked is irrelevant now because the Supreme Court has thrown it out. So now states are left to wonder, using a pretty vague new standard, what is too much government involvement with religion? That new standard holds that the Establishment Clause must be interpreted by reference to historical practices and understandings. How far back in history? Whose practices? Whose understandings of those practices? All good questions that we just don't have the answer to. But these questions will come up a lot, just like they did in our next case, Carson versus Macon. 1 week before deciding the Kennedy case, the same 6-3 split among the Supreme Court held that Maine could not exclude religious schools from tuition assistance programs. This all centers around a situation where a small town without a high school had a public aid program to pay for students to go to high school in the next town over. Here's how the program worked. Town A, like a lot of towns in Maine, has a middle school and an elementary school, but no high school. Town B does have a public high school, so the program allowed Town A to use state money to send students to high school in Town B. But families in Town A that wanted to send their kids to a private religious high school in Town C, or Town B for that matter, could not use that state money. Now, that has been determined by this court to be religious discrimination. We go now to News Center, Maine, where Carly Dion talked with the mom who had a problem with this program.
The Carson family has a close connection to the Bangor Christian School.
I went there in junior high and high school. David went there in high school. My brother went there in high school.
Glenburn resident Amy Carson says that attendance continued with her daughter Olivia. Since Glenburn does not have its own high school, Amy and her husband David feel their daughter's high school education should be covered under Maine's tuition assistance program, which led to this U.S. Supreme Court case. Today, the High Court ruling that Maine's law is in fact unconstitutional. Amy getting emotional thinking of how proud their grandparents would be.
To have your name on something that is so important as this is just mind-blowing.
Prior to this lawsuit, filed with 2 other Maine families in 2018, the law entitled every child to free public education in the state, and the tuition assistance program provided funding to students living in towns without schools as long as the school they chose was not associated with any religion. Although this won't help them as their daughter is now in college, she hopes it will help others.
There's plenty of people that we know that live in Glenburn, and they could benefit from that for their kids.
Institute for Justice attorney Michael Bindus says he is thrilled about this outcome.
This is a tremendous victory and a tremendous day for parents who simply want the ability to choose the schools that are best for their children.
Maine's Department of Education releasing a statement saying the department is reviewing the decision for its implications for Maine schools and will implement the state's tuition program in accordance with the ruling. Maine's Attorney General Aaron Fry says he is very disappointed by this ruling, but it may not be the victory his opposition thinks it is.
If what it is that the state wants to do is make sure that its public dollars go to public education, we're going to have to make sure that we retool how these programs work so that that happens.
Fry says the DOE and legislators will now have to reevaluate this program to determine where it goes from here, ensuring all students in Maine have access to a public education. Carly Dion, News Center, Maine.
Here's the key in this case. As of now, people who want to use this program to send their students to a private religious high school can do that, but that school has to be one that accepts state funds from the program. Private religious schools don't have to agree to accept state money. One reason they don't is because accepting state money comes with requirements and restrictions. In this very specific case, Maine schools that accept government money have to comply with anti-discrimination provisions of the Maine Human Rights Act. Maine Attorney General Aaron Fry said in some cases, the religious schools that could now accept that money do discriminatory things like refusing to admit gay and transgender children. And to accept money from the state would mean they can no longer do those things. So just because this Supreme Court decision in the Carson case allows religious schools to apply to receive public money doesn't mean any of them will do it. Now, I mentioned earlier we'd be talking about another major overruling by this court. So in the case of Dobbs versus Jackson Women's Health Organization, the court voted 5-4 to overrule the landmark 1973 decision in Roe versus Wade, rolling back nationwide protection for abortion rights. Now, there has been lots of coverage on this case. We know the impact there. Trigger laws went into effect. Restrictions that had been on hold because of court challenges went into effect. And a lot of places either banned or severely restricted abortion rights. Now, with the Dobbs ruling, the court has done something it has never done before. It's taken away what it has previously designated as a fundamental right. What we're here to talk about now is what could come next, based on language in Justice Clarence Thomas's concurring opinion calling for reconsidering cases involving same-sex marriage and contraception. So I'm here now with Cleveland Marshall College of Law Professor Abby Moncrief to talk through this and explain what we can expect. Abby, thanks for being here.
Sure, thanks so much for having me.
All right, Abby, can you explain for us how substantive due process, which is the issue at hand here, works?
Sure, so there are 2 clauses in the Constitution, in the 5th and 14th Amendments, that repeat the same language, one that limits the national government, the other limits the states, that says that no government shall deprive any citizen of life, liberty, or property without due process of law. So since the 14th Amendment passed, that has been interpreted to mean not only that governments have to use due process to take away life, liberty, or property procedurally, but also that there are certain dimensions of substantive liberty, certain rights that governments can't take away at all, no matter what process they follow. So that's what's called substantive due process. You would think from just reading the text that what that means is as long as the legislature passes a law saying you can't do something and then holds a jury trial before locking you up, it can take away whatever liberty it wants. That's what the text seems to say, that it's just procedural. But since 1868, from very early on in American history, courts have interpreted that to carve out and protect some substantive areas of liberty as saying, no matter what you do, you can't take away these rights. So that's what substantive due process has historically meant. But as you can see from what it's not like super obvious that it fits with the pure text of the Constitution, which is where Justice Thomas is getting some of his purchase.
Right. So when we think of substantive due process, we think of these unenumerated fundamental rights. Up until very recently, one of those was abortion. So now we look at what could come. There's already a case in Alabama where the state is using the Dobbs case to argue it should also be able to ban gender-affirming medical treatments for young transgender people. So my question is, does that fall in line with the Dobbs holding, and what other issues might now be called into question?
Yeah, so, when it comes to gender-affirming care, unlike with abortion, which was clearly held to be one of those protected substantive liberty interests in Roe, gender-affirming care has not yet been held to be protected under the 14th Amendment. So what's at stake there is not, does Dobbs portend a reversal of an existing right, the way that Dobbs reversed Roe, but rather, does Dobbs set the stage for a holding in the future that this right does not exist, that there's no reason to protect a fundamental right to gender-affirming care for transgender kids? And I think there the answer is clearly yes, that the court has now said its test, that it is enshrining as the test for when it will find implied fundamental rights, is what has been protected in the history of the United States, in the concept of ordered liberty, by history and tradition. So things that were protected at common law in Britain before we became a country, and things that were protected by statutes between 1790 and 1868 when the 14th Amendment was ratified. So if you look at that and you think, well, okay, did you have a fundamental right in 1868 to suppress puberty in order to affirm your gender, your socio-psychological gender? The answer is no, those treatments were not available. Now, and so I think it's likely that if this issue were to come in front of the court would say, we are not going to find a substantive due process right to that kind of care. It needs to be left to state legislatures to decide whether that's available or not.
Lots to unpack there. And now talking about some of the other things that have already been enumerated. What are some of those issues that might be called into question now?
Yeah, so the fear, especially with Justice Thomas's concurring opinion, is that the court will use the Dobbs decision as a reason to roll back substantive due process rights that it has already protected. Things like, as you mentioned in the intro, contraception, same-sex marriage, but even the right to intimate sexual relationships between same-sex partners, which was protected for the first time in Lawrence against Texas in 2003. So those fundamental rights that have been recognized since Roe, and contraception, which was just before Roe, that were recognized under this concept of substantive due process, Justice Thomas wants to say all of those should go away because substantive due process is kind of a sham, he says, right? Mm-hmm. But Justice Alito's majority opinion makes it clear that he's not interested in going there, and I don't think it's likely that there are 5 votes on the Supreme Court as currently constituted for taking away those rights. So what Justice Alito said was that abortion is different. Abortion involves the killing of a fetal life or a potential fetal life in a way that contraception and same-sex marriage and same-sex intimacy don't. So there's no third-party life at stake in any of those decisions. And so he says there's this qualitative difference that's really important about abortion that makes it made Roe a particularly bad precedent in his view. And then Justice Kavanaugh in his concurrence echoes that idea and says, this doesn't threaten all of our other substantive due process rights. It's just abortion that was not a good topic for protection under substantive due process, and it's only that we're taking away today. So if you read the Dobbs decisions in whole and sort of look at the entire analysis, I think it's pretty unlikely that they're gonna, in the short term at least, roll back any of those protections. You'd have to get a much longer tenure of conservative originalist justices, and also I think it's important to note that the court it's structurally not supposed to be responsive to public opinion, but the court cares about public opinion because it can't do anything at all without the cooperation of the political branches. It doesn't have power of the sword or power of the purse. It can't spend money. It can't enforce its laws by itself. It depends on Congress and the executive branch going along with what it says, and state legislatures going along with what it says for its legitimacy. So it cares about public opinion, and there's just not a large groundswell of public support for taking away contraception rights or gay marriage rights or intimacy rights the same way that there's this like really big pro-life movement that wanted to express itself. So, so just predictively, I think it's unlikely that the court will overturn those precedents, even though some of the logic in the Dobbs opinion would suggest that there might be a reason to overturn those decisions.
So just to echo what you're saying and make sure I'm understanding it as clearly as possible for everybody that's watching as well, you're not saying that they couldn't do it under the way the Dobbs ruling is spelled out, but you're saying that they won't. It doesn't seem like there's not the support with the current makeup of the court to do it.
Correct. Yeah. I mean, the court can kind of do whatever it wants. There's nothing that really constrains it from, throwing out the whole Constitution or enforcing the whole Constitution in a very, very rigid, originalistic, historical way, right? Like they could, if they wanted to, interpret it very strictly to mean exactly what it meant at the time it was ratified. But whether they would essentially render themselves irrelevant if they did that. And so the members of the court know that, and they care about maintaining their legitimacy in the eyes of the American people and in the eyes of the political branches. So, I think it's extremely unlikely that they'll go really far against what most American voters want and how we understand our own rights. And I think that's what Alito and Kavanaugh were signaling in their opinions in Dobbs by saying this is really only about abortion and not anything else.
Mm-hmm. Well, there is definitely some debate on the feelings between abortion rights and people who are against abortion, and that actually is the perfect tee up to our next conversation. Abby, thank you so much for being here today. We really appreciate your time.
Yeah, thanks for having me.
All right, so it has been a time of change on the Supreme Court with 4 new justices seated. That's happened in the past 5 years, and one of those appointments happened just after these last decisions were handed down, with Justice Stephen Breyer retiring and Justice Ketanji Brown Jackson being sworn in to take that seat. So now our talk turns to the legacy and the future of the Supreme Court. And here to have this conversation with me is attorney Jonathanenton. He's a Supreme Court history expert. He's from Case Western Reserve University School of Law. Jonathan, thanks for being here on Legally Speaking.
Thanks for having me.
We appreciate your time. And first, I have to ask you, I know that you clerked under the late Ruth Bader Ginsburg. Now, this is before she was on the Supreme Court. This is when she was with the U.S. Court of Appeals for the District of Columbia. I have to ask you, what was that like?
It was a remarkable experience. It was really foundational for me as a lawyer and indeed as a scholar as well. I had an extraordinary experience, and in fact, I had my interview with her just a few minutes after she was confirmed, so that was all kind of a remarkable experience. But she took very good care of her clerks over the years. We stayed in touch almost to the end of her life, and we were all part of a remarkable family.
A fascinating and very valuable experience, certainly, especially if you're going to go into the area of looking into constitutional law. So I want to start with talking about the history of the court here. As we said, lots of debate about people who are for abortion rights, for people who are against abortion rights, and public opinion polls do seem to show that the majority of people do favor abortion rights. So have we ever seen a time when the court has ruled what seems to be against public opinion, as they've done in the Dobbs case?
Well, the court often rules in some ways against public opinion. After all, especially when we're talking about constitutional rights, the whole idea is that we don't want our individual rights put up for popular vote because impassioned majorities might move against unpopular folks. Now, what's unusual in Dobbs is that the court first recognized a right, and now, nearly 50 years later, says, oh no, that right didn't exist. And that's unusual. It's hard for me to think of something quite like that. Certainly the court has overruled past decisions, changed its interpretation of the Constitution, but this one is pretty unusual.
All right, now with the many opinions that we've discussed here today, the court has split 6-3, along the lines of which justices were appointed by Republican presidents, which were reported by Democrats. So let's talk about the makeup of the court. When did 9 justices become the standard for the court?
We've had 9 justices on the court since 1869, more than 150 years. Now, before that, well, let's be clear. The Constitution doesn't say how many justices there will be. It simply says there will be a Supreme Court. At the beginning, in 1789, there were 6 justices. That was tied to the size of the country and the structure of the federal judiciary. As more states came into the Union and the structure of the federal court system changed as a result, Congress incrementally increased the number of justices through the first 40 or 50 years of our existence. Then in the 1860s, this was tied up with a lot of the politics around the Civil War, Congress played some games with the size of the court, but settled on 9 justices in 1869, and that's been the number ever since. There has been only one serious effort to increase the size of the court since 1869. That was in 1837 at a time when the court was in serious conflict with President Franklin D. Roosevelt. The so-called court packing plan failed, but some of the older and more conservative justices soon retired because they were older, and President Roosevelt had the opportunity to appoint justices who were more in line with his thinking. And so that was the last time that there was, as I said, a serious effort, although there had been some discussion about that more recently.
And that's what we want to talk about now, because, you know, it's kind of a young court. Lots of people who have been recently appointed, relatively young, and some people are happy with the decisions that are coming down. Others are not. President Joe Biden was asked on the campaign trail about whether he'd try to expand the court. Most recently, he said he doesn't agree with that. What's happening now with those efforts, if anything?
Well, there are 2 ways to think about this. There's essentially a political approach, which is it's not going to happen in the foreseeable future because Republican senators, whatever their internal disagreements, basically are very happy with the Supreme Court as it now stands. So they would almost certainly filibuster any effort, any bill to increase the size of the court. It's not even clear that as long as the Democrats have control of the Senate, whether they would even be able to change the filibuster rule. And so in that sense, I think we can say that it's not likely. But there are also reasons to be skeptical about the stability of this approach. Let's suppose the Democrats were able to increase the size of the court, and they would have to add 4 seats now to get an effective working majority on the types of cases that they really care about. If that happened, what would stop the Republicans the next time they had control of both houses of Congress and the White House from saying, okay, well, 2 can play at that game, so then they will increase the size of the court, and then we get into this kind of infinite cycle where the court size keeps increasing. So at some level, that essentially buys into the idea that everything that the Supreme Court is about is politics. And I certainly am the last person who will tell you that politics are irrelevant to the law, especially to constitutional law. But the idea that that's all it is, I mean, I think that would be pretty problematic, not just for the court, but for the country. So I'm skeptical about this for institutional reasons, but I also think that this is more of a talking point than a realistic prospect.
Well, it certainly wouldn't be a good look if they were doing that, would it? Just throwing back and forth between the two parties, adding justices.
Well, but the court is already in a place where it doesn't have a good look, and it's not just about Dobbs and some of the other controversial rulings that the court made in this past term. I mean, we are now at a point where on the really hot button contentious issues, you can pretty much tell which way a justice is going to go by which party the president was who appointed that justice. That's really a very new development. Until maybe 15 or 20 years ago, there were outliers. There were some Republican appointees, Justice Stevens, Justice Souter, later in his career, Justice Blackmun, who were not reliably conservative. And there were some Democratic justices, Byron White, whom Justice Ginsburg succeeded, is a good modern example. Justice White, in many respects, was a lot more conservative than many of the Republican justices. But because the political stakes of the Supreme Court have come to be viewed as so important, people are, of both parties, are trying very hard to come up with reliable justices who will take the positions that these folks want. And it's interesting to think about this. You know, when Justice Ginsburg was first nominated, there were some folks on the left, some liberals, who were a little skeptical because they didn't think that she was sufficiently reliable. Justice Ginsburg, in addition to having litigated almost all of the major gender discrimination cases that the Supreme Court decided in the 1970s, Justice Ginsburg was an expert on procedure and jurisdiction, and she took those things seriously. And as a judge, it was not unusual for her to say, a claimant who's asserting an argument that she might sympathize with on the merits has to lose because there are procedural or jurisdictional issues. Now, it's true today that some of the Trump justices are not always lined up with each other in every case. Think about some of the Indian rights cases where Justice Gorsuch has broken with some of the more conservative justices, or Justice Gorsuch, joined by Chief Justice Roberts, supported the interpretation of the civil rights laws to say that employment discrimination based on sexual orientation violates federal law. That was a hugely controversial ruling. Justice Gorsuch actually wrote the opinion in that case. So I don't mean to say that on every single case there's a clear ideological position, but I do mean to say that we are much more focused on these hot button issues, and so justices are expected to go with the party position, and that influences who gets appointed in the first place.
So, if I'm hearing you right, you're saying not likely we're going to see any changes in the number of the people on the court at any time.
I do not think that is very likely.
All right. Thank you for your expert opinion here, Jonathan. We really appreciate it.
Thanks for having me.
Laws change all the time. The way we, as a society, think about them and interpret them changes. New things come up and new laws have to be made to deal with situations that maybe we weren't presented with before. We're here to talk through it all and keep you as up to date as possible so that you can make the best decisions for your life. Thanks for being here with us. I'm Stephanie Haney, and this is Legally Speaking.